to this court for a maximum of 6 months from this date. Because within 6 months, the state should have prepared committal papers for committal proceedings if they have the evidence, and other arrangements will then be made regarding your reporting. Failure to commit the accused persons for trial within 6 months from this date will result into their automatic release from the terms and conditions of this bail release. And that will mean the release of the sureties as well. And they will be discharged if state fails in 6 months from this date. I don't know mathematics, I would have given the exact date. I saw orders.
Omulamuzi wa kkooti ya International Crimes Division Justice Susan Okalanyi ate okukangula ku ddoboozi eri gavumenti ng'agiwa ensalesale wa myezi 6 nti singa gigwako nga temaze kukungaanya bujjulizi obulumika bannakibiina kya FDC Katonga faction 36 abo abakwatibwa ekisumo mu ggwanga lya Kenya okusinziira ku bba agamba nti abantu baabwe baali bagenze kwongera kuyiga ebyobufuzi bikwatibwa bitya ebyo bya kisajja kikulu naye ate gavumenti negamba nti nedda kino baali bakyekwekamu bwekwesi ng'ebigendererwa byabwe byanjawulo era nebakwata nebakomyawo waneeno nebasimba mu maaso g'omulamuzi mu kkooti y'e Nakawa ate gye baasindikibwa okuleetebwa eno mu International Crime Division okubeera nga bawozesebwa. Kati kino nno omulamuzi okukangula ku ddoboozi bw'ati eri gavumenti okugiragira enoonye mu bunambiro obujulizi kidiridde omuwaabi wa gavumenti okutegeeza kkooti eno era kino kibadde kireeteddwa ng'akakwakulizo kerina okwesigamako obutawa bantu 436 bail nti singa ebawa ate okunoonyereza okukyagenda mu maaso kujja kuba kutataaganyizibwa era n'ategeeza nti kukyagendera ddala mu maaso omulamuzi kyagaanye. Bwe bityo bwe bibadde CTN News tubaddeyo butereevu nnyo nga tubigoberera era nga tulaba byonna bwe bigenda mu maaso. Kati gwe atugoberera tukwebaza okwereza obudde n'eddata atana subscribinga tubakubiriza mu subscribinge tusobole ate naafe okufuna amaanyi agabeera nga tubanoonyeza ebintu ebyenjawulo. Mu kkooti bingi bigenze mu maaso era omulamuzi abadde ng'aleeta moment obw'okusaagako n'enjuyi zombiriri lwe bavunaana n'oluvunaana kwegamba okulaga embeera eyo kubanga almost olunaku lwonna okuviira ddala ku ssaawa 3 okutuuka ate ku ssaawa nga 9 awo kitundu almost kkooti ebadde ekyatambula. Kati olaba nga obudde bubadde buwanvu and that kind of ebyo ebigambo ebyo ebisikiriza oba ebisanyusa byataddengamuuko nabyo ndowooza biwadde abantu mulalo naye ono era ataddeko oba ebibuuzo byabuuzizaako ku ludda lwa gavumenti nga yennyonnyolako abimyumyuddemuuko. Ndowooza kino akikoze okusobola okufuna ekyo ekituufu kyasobola okwesigamako ate okuwa ensala ye bano abawa beyiro oba tabawa. Era na bano ababadde bakulembeddemu abavunanibwa nga bakulembeddwamu Ssaalongo Elias Lukwago omulodi wa Kampala balooya abeera nabo abanyizeemuko ebibuuzo awo akakase kituufu abantu abaleeteddwa okweyimirira 436 beebo abasaanidde. Kati bwe bityo bibadde mu kkooti nkugamba tubaddewo obutereefu nnyo nga byonna tubikungaanya era gye biggweredde nga 436 beeyimiriddwa ku bukadde 2 buli omu ndowooza zezo miliyoni 7.2 ate ababeeyimiridde nga buli omu alina kusasula obukadde 5 obwa kuno naye nga si bwa buliwo era n'obukwakulizo obumu obuteereddwa ku beeyimiriddwa weewaawo baweereddwa beyiro balina okulipootingangayo omuwandiisi wa kkooti eno buli mu mwezi omulundi wakiri gumu ng'akakwakulizo. Tebateekeddwa kufuluma ggwanga nga tebasabye oba tebafunye lukusa okuva mu kkooti eno. N'ebintu ebyabakwatibwako ebiwobe ebyabagibwako gavumenti omuli endagamuntu, paasipooti, laputopu n'ebiringa ebyo bye baalina e Kenya. Omulamuzi alagidde bireetebwe mu kkooti eno naddala paasipooti n'endagamuntu ebyo ebisobola okubakkirizisa okufuluma eggwanga oba okutambula wonna we baba baagadde alagidde bireetebwe. Kati byonna tubikungaanyizira tubaddewo butereevu nga kamera zaffe zitemya bukofu bwe biti kkooti bwetambudde okuviira ddala ku ntandikwa ate okutuuka omulamuzi wagabidde bail era n'awa ebiragiro nga bw'ogenda okubiraba era n'ategeeza nti yani judgment mu bujjuvu oba ensalawo ye nga ziko ajja kuba nga ate agiteeka ku mails z'abannamateeka abali mu musango guno. CTN News kwoli nkwebaza otugoberera katutambule kkooti bweti bwebadde.
One Uganda,
one people,
one people,
one Uganda.
I hope you know that this is not a rally. This is a court of law. Can someone go and tell the people outside that there's no market there? I'm being distracted by the conversations outside. Are all the applicants present? Makoha Samuel, Tarondra Simon, Dr. George Okelo Ekwaro, Konge Charles, Kawanguzi Paul, Nasum Din Basaliwa, Waiswa Latif, Maido, Bukenya Charles Wanga, can I have the applicants stand in the order that they appear? So that is easy. I think I have seen Kenya Charles Wanga. Where's Kenya? Kenya is number 8. I'm sorry about the space that you are trying to scan. That is why I had wanted to have the code out so that the accused persons, who are the applicants, would sit behind me. That was my plan. But anyway, we can still proceed. Chitamirike, Okunyizza, towards the side. Sarah John Manyeni, Bukenya Happy, Olinga Sozi Peter, Sos Peter, Obang Walter, I don't know what this is, Chankara Moses, Kaigo Yosia. I'm not seeing you. Okay, I'm seeing your face. Wanzike George. Museveni Innocent. Achivinge Edward. Achivinge Edward Wasajja. Beinomgisha Adios Denmark. Muhinda Rona, Kungu Henry, Nakuba Ronald Sozi, Chugabirwe Richard, Okelo Sirino, Ahimbisiwe Owen, Simon Peter, Wakabi Adam, Chimombe Konos, Buyondo Henry, Ngobi Fairuzi, Owamani Robert, Kukumisiriza Asa, Owachgiwu Asa, no, Dennis. Lalam Florence, standard, the lady standard, for a while, who is Nalu Kuma Grace, Apale Salo, what languages do the applicants speak? They are all conversant with the Queen's language.
Yes, my lord, we can all speak.
Do you have a translator? Want it? Can I have it? Moses. Mwonge.
My lord, for purposes of persuading the solar court, not as an exceptional ground, my lord. My lord, in an attempt to rebut our contention, the state has put in an affidavit. The reply filed an affidavit on the 3rd of October, 31st rather, today morning, which has just been served on us. And I would like to address you on paragraph 6 and 7 of this particular affidavit, my Lord. But in response to paragraph 8 of the applicant's affidavit in support, the investigations in this matter are still incomplete, and the applicants will interfere with the same if released on bond. That's paragraph 6. Paragraph 7, that in reply to paragraph 9 of the applicant's affidavit reply, the applicant is jointly charged with 35 others with serious offences, with strong evidence against them, and it is my strong belief that they will frustrate the trial process if released on bail. This paragraph runs through all, runs through all the affidavits. It's kind of replicated or regurgitated in all the affidavits, my Lord. And that is the strongest ground the state has brought against, opposition rather, they have against the application. My Lord, would like to address you on those issues. It's our contention, and rightly so, my Lord, that those averments are speculative in nature and cannot be used as a justification to defeat the letter and spirit of Article 23 of the Constitution, as well as Article 28, which guarantee the right to liberty, the right to access, to be admitted to bail, and the right to be free by this honorable court on conditions that court may consider fit and proper. So in other words, it's an attempt to defeat the doctrine of the presumption of innocence, my Lord.
My Lord. Unusually, I will not take a lot of time.
I was just preparing to even order for lunch and leave. Because I knew hunger would finish me.
No, my lady, you have already said there is a lot of the gum is becoming hot. So who am I, my Lord, to make it hotter? My lady, Richard Bili from Bukadde responded. In response, my Lord, we object to this application. However, we shall not go too much detail, my Lord. We shall just pick out a few areas where we think court should be concerned. Yes, my lady. My lady, first of all, we do appreciate the fact that it is the right of the accused persons to apply for bail, as rightly put by my senior colleague, the Lord Mayor, but it is a discretion of this court to grant. My Lord, there are several areas, my Lord, that court looks at before an application is granted. One of them is whether the applicant or the applicant has substantial. My Lord, it is a submission that none of the applicants has substantialities. My Lord, I just substantiality of a surety is not a matter of status, but it can also be considered in some other way. One, the distance between their residences. Much as this court has jurisdiction, which is universal, it is important that court takes into consideration the distance between the surety and the accused person. because this has an element of how the surety is likely to control or is likely to ensure the availability of the applicant in case court wants there. Then the other issue is about the sureties themselves, where sureties live apart. For example, you have one surety living in Jinja and one living in Luwero. The distance might not matter. So it's not all about the status of someone. I just want to submit that there is no person who is supernatural. I may be an advocate, a respected advocate, but I may not be at the same. I cannot be in two places at the same time. So there are some things which may be out of control. So, my lord, as you're considering this application, you look at the distance between the sureties and then the applicants and the sureties themselves. My lord, it's so important to appreciate the fact that yes, there are some.
What do you want the sureties to do?
I don't have a question.
To hound the applicants, saying, where is he going now? Where are you going? Come back. Is that the duty?
No, what we are talking about is that when the surety is within proximity of the applicant, the level of control is high. It is high. Just that's the logic of bringing up my friend.
Even with mobile phones and email and TikTok and Facebook.
It is possible to communicate with someone
I
who is
know
not
where
speaking.
you are.
It is very hard, my lord, when someone is not speaking. But when you're closer, it becomes easier for you to even follow up physically. It is my submission, my lady. The other issue, my lady, I wanted to talk about is the data which have been presented for the surety. Just looking at how substantial a surety is.
What is the issue?
The issue of the data, my lady, is that you look at them and find out if, yes, they may have disclosed that the person has residence, but in cases, especially serious cases, my lord, it's imperative that the surety has a fixed place of abode.
But you are not pointing out anything wrong with the records.
My lord, most of them do not disclose that the sureties have fixed places of abode. For court entrust them. Yes, the surety. The rate as introduced in do not disclose that they have fixed places of abode.
Have you ever seen people with mansions running away? And leaving their mansions behind?
I know, my lord. But you're taking me
I was just thinking, you remember the other bail application?
Yes,
The last one.
I do.
When I informed you that I don't have a fixed place of abode in Kampala. And that means you wouldn't give me bail in Kampala if I fell into any trouble. And you know that is not a thing that you can say is impossible now. Can you? So, for me, without a fixed place of abode in Kampala or Wakiso, I'm in trouble. Because my fixed place of abode is in Toronto. And then I come from Bukadde. What will happen? You submit that, you see, you don't come from Toronto and you have a house there, but why don't you have a house in Bukadde? And I'll tell you my ancestors didn't give me a house, land.
My lord, people of your background may be up to you. Otherwise, in Kampala, I'm not an
Everybody
expert.
has a house?
No. I'm just cementing my submission on this, my lady.
Okay.
I may not go into the nitty-gritties of that, but I'm saying my submission is that people like you are few, my lord. But in Kampala, I'm not submitting as an expert, but there's a lot of nomadism. Moving from one house to another. When the landlord increases rent, the person is likely to actually move on. This is what we're talking about. Which doesn't happen if the person has a fixed place of abode. That's something we want you to look at. I am not submitting generally that there are no people who are renting and they have stayed in places for longer, like you, my lady. But it's also true that some people move after 5 months from one place to another. That's something which, yes, something which I'm asking you, my lord, as you consider this application, you look at that.
But you are not pointing out to me, you are not asking the court, which of these applicants has no house in the places they are staying. You are not assisting.
I have been very clear.
I'm looking at the letters.
My submission is that the letters of introduction should be able to show that a person has a fixed place of abode. That's the point I'm trying to bring up.
I hope
the
applicants council are taking note of that. That it is important to say that the person, the LC to say. Let me just look at see the problem with some of the LC letters. The LC introduces the person, they say his or her household number is this. But then I want to ask you, what is the fixed place of abode? Because I can tell you, it does not mean that you own the property.
Yes.
Fixed place of abode.
Yes.
International does not mean that you own. It's your known residence.
There are about three issues, my dear.
Yes.
Away from owning, the tenants agreement can speak volumes. And then the period the person has been in a place. My dear, for example, your scenario, where you have been a tenant, I don't know, that's why you intimated, for 11 years.
11? Since 2011. Yes.
For that long, my lady,
yes.
It talks about, it speaks volumes as to your permanence. You can be regarded as a person with a fixed place of God.
I can run away at night. I fall in trouble.
So, my lady, if not tenants agreement, then you can have receipts of payment.
Okay.
Yes. For a period of time from which court can deduce or can think otherwise that you have been there for such a period of time, and therefore one can consider to have a fixed place of abode. So these are things, my lord, I'm just asking court to look at. As I said, I'm not going to go into nitty-gritties. I'm just going to point out issues, my lord, and this court can look at after. My lord, the other thing I want to
agreement on receipts, land titles, for those who own, what's that? Marriage certificates for those who have presented their spouses. They might just be cohabiting, isn't it? Which is not allowed.
That's not my mind. I just speak my lord. Yeah, I also wanted to refer to the nature of work that should do. What should take into consideration? I've been hearing my friends, senior friends, arguing that the sureties are capable and they will abide by the conditions and everything. But you see, when you talk about that, then you must prove. And how do you prove that? You need to bring in the issue of the financial ability of the surety. Without that, you better remain mute. And you simply assume that the surety will be able to indemnify court in case the applicant absconds.
Basically, you are saying that the applicant's counsel
overseers.
We are just talking from the back.
Exactly.
Yes, without substantiating the so-called employment and capability to indemnify
in case of anything. And besides, my lady, if you're careful, apart from submitting that such and such a surety is engaged in such and such a business, there was no proof of that. So in other words, they were submitting.
In your reply, you remember that these statements that they have made, that the applicants were making, they were reading from an affidavit.
Yes, that's true.
Have you replied in rebuttal of those specific issues that think are not true?
Yes, my lady. I would refer, let me refer you to, paragraph 5. Paragraph 5 of the affidavit in reply by AIP Natumanya Nelson Bamanyisa.
Yes,
This particular paragraph is in respect to the substantiality of the sureties. And we're clear that we denied their substantiality and we said, we have that they will be put to strict proof. Strict proof means producing evidence to show how substantial you are. You shouldn't be hard to say you're CEO of a particular company. You have an ID. 2, does the company exist? Is it undergoing insolvency? Because many of these companies are just briefcase companies. They're not operating. So if court just took it like that, that someone is the CEO or is a managing director of a particular company without proving otherwise, it would be a risk. And in this case, it was never proved. And we put them. In fact, if counsel for the applicants were keen on this paragraph, they would have sought an adjournment to go and prove this particular paragraph. And said, yes, surety number 1 is a head teacher. This is his appointment, yes, or AD.
Appointment letter.
This is a person who is the managing director of a particular company. This is the company and this is his identity card. We put them on notice. And in matters of bail application...
You put them on notice
yes.
This morning?
Yes.
So they should have sought for
yes.
An adjournment?
Exactly.
Okay.
And my lady...
That was according to your paragraph 5.
Yes, my lady.
Go ahead.
And none of the sureties are actually proved so. The other thing, my lady, if we want to submit, as I said, today is not a day for over-submitting. There's the fact that
Yes.
Some of the sureties are really, even without other proof, you will see that they are, for example, okay. No.
They are lightweight.
My lord, you consider that. You consider that about sureties in your ruling.
What? I don't know what you have told me. I don't understand.
I had some students, some farmers.
You are joking with farmers?
Yes. Yes.
Oh, you meant peasants. So if you are only relatives that can stand there for you are peasants, the court should not consider them substantial.
My lord, court can look at that. Court can look at
No. What are you advising me to do?
my lord, yes.
I'm just trying to imagine those people who don't have heavyweight shoes in terms of money, big jobs, member of parliament, former member of parliament, secretary FDC. All you have is your money from a molata. 2 grows cabbage, tomato, and borrowed money to come to court, to the High Court in Kampala. That person who is struck with poverty should never ever get bail in any court of law under the guise of substantiality.
My lord, they have not submitted like that.
I am trying to fix the gap.
That was never my submission, my lord.
Okay.
But I just submit that you look at the sheet presented in this court. senior colleague submitted on the seriousness of the offence as being one of the issues that state laid on to object in the bail application.
Yes.
Whereas I agree with him, that's not a ground. It's not a ground to curtail the rights of the applicant. It is also a ground that courts look at to grant or not to grant the bail application. You cannot
What
overlook.
about seriousness of the offense to the court? You are not guiding me.
But I just don't how. Because, my lord, misdemeanors shouldn't be the conditions under matters of misdemeanors cannot be the same in. Yeah, this is what I'm trying to point out. It's not a redundant point.
Yes. After the Honorable Justice Swatter's decision, what do you want me to do?
My lord,
To start my own principle, debating.
my lord, it is persuasive.
It's persuasive.
And remember, my lord, my senior colleague cited section 14 now,
Yes.
which says court may.
Nay.
So, my lord, if you
This whole thing is complicated. This bail application thing. I don't know when I will understand. It will take years.
my lord, you can set your own precedent the way she did.
Go ahead.
Yes, the other thing, my lord, I wanted court to look at is the issue of the fact that inquiries are still incomplete.
Quiet.
Yeah, they are still incomplete.
Yeah.
The possibility of interference.
I don't like this point of view.
How you do?
You see, even the point on seriousness, had you prepared committal papers, I told you that would give the court knowledge about the problem that has brought these people before me. It would help the court very much. And the other case, I don't know whether it's the case of Kiza BCA or Foundation, where the Chikonyoko said that nothing prevents the prosecution from adducing evidence in the bail. I have forgotten, because it's such a long time since I was on the other side. Proceed with the inquiry is incomplete. Add more flesh.
My submission is that
You want
the
me to
possibility.
consider that fact?
Yeah.
When will inquiries be complete? You see, inquiries are not complete. Has been used as a ground or an excuse to keep people beyond the 48-hour rule who have already been arrested. And then the inquiries in one of the cases that I recently decided on a trial within a trial, the person was in custody for over 6 months. Recharging time. So when will inquiries be completed in this part?
My lord, I may not be specific. I may not commit the office of the DPP because this matter involves two states.
How long have the Africans been on your mind?
Close to 2 months. No, I am not a person.
Can you have your file?
I didn't come with a file.
Yeah.
Yes, so it can be about 3 months. No, it's not very comfortable. I was not assertive.
You correct the nearest, it's in mathematics.
Go ahead. Can you
I hope my lord I'm protected.
You are saying?
Yeah, that I may not commit the office of the DPP in respect to when the inquiries in this matter will be complete, because this matter involves two states. And it's not the procedure is a bit complex.
What is complex? Kenya here.
That's my it is a sovereign entity, my lady. It's a sovereign entity, my lady. So sometimes it's not as easy as you may think to get information. So that's what I'm talking about.
What is so?
Melody, it is not easy to get all the information.
I can assure you that Kenya is a very cooperative state. Kenya, Tanzania, and Uganda, the original members of the community, have very good working relationships. As far as judicial cooperation is concerned, I don't know political ones, but judicial cooperation, we have benefited from the collegiality among the stakeholders.
I will not say within 2 months. That's what I'm trying to say. There may be cooperative.
So you are not, you don't know.
Exactly.
Okay. Because of the transnational nature of the case.
Exactly.
All right. Noted.
My lady, it is a submission that if this court is inclined to grant this application,
Yes.
because which is within the discretion of this court, we pray for stringent
Such as.
terms. Such as cash bail,
Yes.
not moving out of the country without consent of this court. Also reporting to the High Court, ICD division. ICD division. My lady, I've sat since morning. And I'm not happy.
And you're unwell.
Exactly. It is understandable.
My apologies for making you go through in your illness.
My lady, that is acceptable.
Okay. Thank you.
The question of sureties, my lord. We reiterate our prayer that we find them substantial, having satisfied the requirements of the law, my lord.
Don't you think there is a point that Council for the State is making regarding these LC letters? That lazy lawyers just go and get pre-typed letters. I have seen some of the letters, very good, handwritten by the LC, talking about the issue. You know, meaning that the person who went to when the applicant's surety went there, the LCs understood the purpose. Then I'm seeing others which are already typed. They include even issues like applying for loans, and they just ticked the right one, surety in court, without explaining a thing. So I think we in the legal profession should stop being this.
Not the members of the legal profession doing this. My lord, that requires intervention of the judiciary in the practice that is going on countrywide as far as LCs are concerned. You know, LCs have got a dual role under the 2006 Act.
Yes.
They are judges actually at that level.
They have their cases.
Exactly, my lord.
But not all cases.
But it pains some of us, my Lord, that no standards have been set as a matter of course. No requirement for education, qualifications, nothing. Then anyone from anywhere, from whatever background, can become an LC chairperson. And that, my Lord, it will be...
And needs money to write a letter. That's what you are saying.
Yeah.
I just said it myself.
They call it facilitation. It's called facilitation, my Lord. They are not adequately facilitated by the state.
Yes.
And
the office is not well organized.
Exactly. So that requires a grand reset countrywide, my Lord, and can't be visited
What
on
about
the applicants.
the issue of employment?
The issue.
The surety says that they're a teacher or that they own a company.
My Lord, I was looking at the guidelines, the practice guidelines,
Yes.
the Constitution guidelines for courts of judicature, practice direction 2022, particularly regulation 15, determining the suitability of a surety.
Yes.
When considering the suitability of a surety, court shall take into account the following factors: the age of the surety, work and residence address of the surety, character and antecedents of the surety, relationship to the accused person. That is all your, my Lord.
It's a guideline.
It's a guideline, yes.
And when the stakes are high, usually the court moves higher in terms of requirements. And I have a case that I just dealt with the other day, where I was given more than I ever needed. Although Chief State Attorney still got up to challenge it. But there was enough documentation supporting almost everything. And that standard is what we should, generally speaking, when we make these applications, stick to.
My Lord, yeah.
Especially if it is possible.
I appreciate all that, my Lord, but the point here is...
If someone is a teacher, someone was an LC1 here. In that case, there was an LC1 coming from Colombia. And Buka's submission was that, what can we even know that this man is an LOC? Is this even an LOC? Then he checked his pocket and came out with evidence that is actually the LOC1 of that cell in Colombia. You see, that nature of preparedness. But you proceed. I don't want us to. I was just notifying you on that.
My Lord,
we are overstaying.
yeah, my Lord.
And they have stood. Although they are the most fit people now, the people who are having problems are us who are sitting. Yes.
Yeah, the fact that actually we have produced witnesses, my Lord,
Yes. Surety.
the sureties is enough to demonstrate the importance and the gravity we attach to this, my Lord. Because, my Lord, even within the jurisdiction of this, with the jurisdiction of this honorable court, you are seized with wide powers, discretionary powers, to grant bail with or without sureties. But we are making it a point that we have to produce sureties. And now on the substantiality of the sureties, my Lord.
Why the courts insist on sureties is because we need a fallback position when people become stuck. And we have had cases where we cannot proceed, and yet someone was released. And when you look at the facts of the case, the question of substantiality was not considered properly. Otherwise, the person would not have been released. And that is why, you know, it kind of becomes a problem. And if another judge releases and the case is given to another judge to try, I've had a judge say, give the case to her. She's the one who released the person.
We appreciate all that. But his is far-fetched. Our submission that it is far-fetched. Now it is twofold. His contention is twofold.
Yes.
One, the permanent place of our court. His understanding the state is that it should be a permanent house. That's the way we understood here.
Yeah, no.
Ownership of a permanent house.
He explained it that either you own it Or if you're a tenant, you produce an announcement
Our
or
contention,
receipts of payment of rent.
our contention, my lord, once there is a communication from the LCs recognizing and acknowledging that this person resides within our area of jurisdiction, and it has not been rebutted, we invite this honorable court to treat that as sufficient evidence, my lord.
Yes.
Related to that, my lord, some of the sureties have proved that they have brought evidence from their places of origin.
Yes.
Not necessarily in Kampala or Wakiso here,
Yes.
but from as far as Veche, Kanungu, wherever.
Yes.
They have come from as far as those areas with that kind of evidence. These are their places of birth. That's where they were
Can you
born.
also respond to council's submission about the distance between the parties, the sureties and the applicants, and the first and second surety as far as their residences or homes are concerned? He thinks that because of that they will not be capable of fulfilling their duties as sureties.
My lord, the phrase he used, the level of control. The duty of a surety is not to control the accused person, the movements, to control the movements of the accused person. I think that would again be far-fetched to say that you are maintaining 24/7 surveillance about the movements of the accused person. That would be far-fetched. It's about reminding the accused person to return to court, ensuring that actually the accused person complies with the conditions, and that can be done even if you are not within the vicinity, within the proximity.
Yes.
And my lord, in a digital world where we are now, I think matters have been simplified. The communication is very easy. You can always be in touch with anyone. And I've seen, my lord, right now, court here can even conduct proceedings digitally. It can be done here electronically. So why not the accused person is also conducting business electronically? If court can conduct its business here electronically, this can also happen. So my lord, our submission is that that would be an onerous condition if it was imposed, that they have to be within the same locality. Yes, my lord, on the question of inquiries, the possibility of interfering with witnesses.
It was not substantial.
Now, the evidence. There is one element, my lord, they talked about in affidavit here in paragraph, which he submitted on paragraph 7. My lord, the applicant is jointly charged with blah blah with a serious offense with strong evidence against him. This is applicable to all of them. That there is strong evidence against the accused persons. That is relating it to incorporate investigations. The two are not concomitant. Most obliged, my lord. My lord, on the question of stringent terms, that is the last one. He has invited the court to impose stringent terms. And my lord, we are humbly seeking for indulgence of court on this matter to be considered. Looking at the circumstances of this matter, my lord, where the accused persons were picked from Kenya, brought here, and from the record from the governments, my lord, they spent close to a week in police custody. They have been on remand for the last 3 months. They have families to take care of, and so on and so forth. My lord, if again onerous conditions are imposed, like cash bail, which may not necessarily be readily available,
We normally post cash day if we go out.
It's the reason
So tradition.
my Lord, it's the reason we are asking for, we are seeking for your indulgence, my Lord. Exercise your discretion under those circumstances to make it moderate, my Lord. Because, my Lord, if it is in the terms as requested by the state, it may not be in consonance with the capacity for the witnesses to meet the conditions, rather the applicants. So it's our prayer, my Lord, and that the justice
The
of
offense charge that drops the punishment of how many years?
my Lord, we agree.
What is the punishment? This is with the state council for terrorism.
My lord, also they have the charge sheet,
No, I'm asking you.
but she's yet in prison.
Life in prison.
My Lord, the first case we cited of Dr. Chiza SG
Yes.
was a case of treason and rape, but he was granted non-cash bail. So if it could persuade this honorable court, my Lord, to put all those matters into consideration. And in most of these cases we have cited, in the one of Mumbere, whatnot, the one of Mumbere is life in prison.
What was the bail?
My Lord,
The bond terms.
it was 100, not cash. 100 million.
100 million, not cash.
Not cash.
That's a nice one.
So we pray, my Lord, you be pleased to admit them today, so that they can regain their freedom and liberties within the party of the Constitution.
It doesn't change anything. The reasons shall be given on Tuesday by email to counsel for the parties, who should leave their emails behind with our worship, Yvonne Nasuna, the registrar, the magistrate in charge of my chambers. So leave her your email addresses so that you get the full ruling of the court. As for now, I am giving an abridged version which is that the applicants are entitled today to apply for bail, and the court is entitled to either grant it or refuse to grant bail to an applicant after considering all the circumstances of the case. In this case, the offense charged of terrorism is bailable, and the court has decided to grant bail to each of the applicants in this case. Don't make my tempers clear. This is not the party headquarters of any party where you do the clapping, okay? Because here I am not interested in the clapping. Whether you clap or you don't clap, I will still get my salary. My decisions. So, what are the terms? Each applicant shall execute a cash bond of 2 million shillings. Each surety of the applicant shall execute a non-cash bond of 50 million. Non-cash bond for each surety. I don't know where the applicant's passports and IDs are. But I order that their passports be deposited, those that have passports and travel documents, to this court with the registrar, the deputy registrar of this court, for her custody and safety. None of the applicants shall travel out of the country without the permission of this court through the deputy registrar of this court. So if you want to travel, you come for permission to do so and pick your passport or travel document with the registrar of this court. The registrar of this court shall notify the immigration authorities of this country of this restriction to your travel. I mean, you might choose you might decide to smuggle yourself because Uganda has borders for it. But I hope you don't. She shall notify the immigration authority of the order limiting your movement and the conditions. The condition is permission. Permission from the court. Each applicant shall report to the deputy registrar once a month. And that calculation of once a month will be made from the date of your release by the registrar. She should tell you and inform you of your next date of reporting to this court. Which shall be notified in your bail bond form. You will report to this court for a maximum of 6 months from this date. Because within 6 months, the state should have prepared committal papers for committal proceedings if they have the evidence, and other arrangements will then be made regarding your reporting. Failure to commit the accused persons for trial within 6 months from this date will result into their automatic release from the terms and conditions of this bail release. And that will mean the release of the sureties as well. And they will be discharged if state fails in 6 months from this date. I don't know mathematics. I would have given the exact date. I saw order.
Kkooti bw'etyo omulamuzi bw'akutte ensonga abawawaabirwa abawadde beyiro babakkiriza okweyimirira nga buli avunaanibwa alina okusasula obukadde bubiri obuliwo, ate ababeyimiridde buli omu nga bamwetaagako $5,000 buli eyeyimiridde naye nga si za buliwo. Ekirala omulamuzi ky'awadde wano bajja kubeera nga balipootinga eri omuwandiisi wa kkooti eno buli mu mwezi. Ate yo gavumenti agiwadde emyezi 6 singa eremererwa okuleeta obujjulizi obubaluma ejja kubanga bano ate abata. Kitegeeza nti gavumenti enaaba eremereddwa okuguwanirira nti emyezi 6 bwe kigaana ajja kubanga abata badde ewaka ewaabwe balye butaala. Bano abaweereddwa beyiro abataddeko conditions nti tebalina kufuluma ggwanga nga tebafunye lukusa, era yena afuluma ajja kubaaziza omusango. Era nategeeza nti regisita oba omuwandiisi wa kkooti eno ajja kubeera nga ategeeza bekikwatako oba ofiisi evunaanyizibwa okufuluma kw'abantu mu ggwanga. Era Ssaabasino nga bw'olaba ndowooza libadde ssanyu nga bw'olabye abantu baabwe abazze okubeyimira n'okubaawo nga bakuba mu ngalo ng'akabonero akasanyuka. Dr. Kanukisa Besigye abaddewo, Elias Salongo Elias Lukwago naye abaddewo era nga yakulembeddemu ba lawyers. Philip Wafula Ogutu kono yaliko omubaka wa Court Centre naye abaddewo n'abantu ab'enjawulo. Kkooti bwetyo bwetambudde wano ku International Criminal Division Kampala ng'ewulira omusango gw'abaana FDC 36 abaakwatibwa nga bajjibwa mu ggwanga lya Kenya. CTN News yekuleetedde bino byonna era ojja kubanga ati okufuna ebirala byonna naye ekirala kyotosobola kwerabira nti ensalawo y'omusango guno mu bujjuvu omulamuzi ategeezezza nti ajja kubanga agiweereza oba agiteeka ku mailozi za bannamateeka ababakiikiridde. Ensalawo eno ebadde brief buli omu okubeera nga ati ategeera omusango ogumusalira. CTN News bwekityo bwe tutambudde kkirizaako atano subscribe nga bingi tujja kuba nga tubireeta ekaddo subscribe nga mulike nga musharinga videos zino atege mafuta naffe gemutowa. Naye kyolina okutegeera nti abasibe yadde baba batadde ate tekibeera automatic nti batambula ne baddayo ewaka ewaabwe basooka kuddayo mu kkomera gye babadde ate nga process egenda mu maaso ey'okusasula obukadde buli obiri ng'ate obukadde buli obubiri baweerezwa obwotadde n'ensonga endala ze baba balina okusooka okumaliriza.
Kisooka ng'akulembedde mu ttiimu yaffe eno mbeebaza omulimu ogukoleddwa. Ttiimu eno gye mulaba ey'abannamateeka ebadde tetuula nga mugulabye omulimu tegubadde mwangu. Abantu baffe okuva lwe babakwata ng'ennaku z'omwezi 23 Julayi ne babajja e Nairobi ne babaleeta e Naggalama ne bamalayo kumpi na wiiki namba nga 29 ne babatwala mu kkooti e Nakawa ne babagulako emisango. Embe okuva olwo lwonna mbirigo ze tubaddemu okuviira ddala nga 23 Julayi okutuusa olwaleero mbirigo nga tetutudde. Babazizza wano babatutte ekitalya babatutte ruzira nga tubadde mu mbirigo n'okukola ku nteekateeka ez'okulaba nti tufuna bail application. Ekyennyamiza nti n'okutuusa kati state yo tennaleeta bujulizi tebuliwo era tebannaba committing era n'omulamuzi mulidde mu jaaji mu lulingi akyogeddeko ng'alaga nti naye ebbanga lino lyonna nga temuwozesanga bantu bano era mu lulingi eyo gye twebaza omulamuzi akiraze n'aga nti naye mmwe bwe mutakikola myezi 6 abantu bano zijja bajjako okukwakulizo. Kirala twebaza omulamuzi nti musango bail application ebadde mpanvu kuva ku makya ebintu bibadde bingi gavulimu nga mugalabye naye n'asalawo n'agamba nti rulingi kagiwa olwaleero eri detailed n'agiwa olulala. Ekyo kikolwa kibadde kya bwenkanya nnyo oga nti kasooke atuweerewo ekiragiro ekiga nti abantu baffe babawadde bail okuggyako nti kwakuliza obubiri mu mwaka esente $2 million kyo kitegeeza twetaaga $7.2 million bantu 36 si sente ntono ekyo kibanga emitwalo gya $2. So tulina okugenda tugulube nazo akaseera kano kubanga tezibeerawo nti tuzirina ffe tulinga bannaffe bali abali mu state sente beziyitaba nga bakwata mu kitafu kya ggwanga. So tugenda kuddayo twekwanye tulabe nti tufuna sente ezo. Ekyokubiri kyekiragiro ekigamba nti passports zirina okubeera deposited wano kati ate tugenda kuguluba na state olw'ensonga nti passports ne identity cards ez'abakyuzi bantu bano bajjako nga babakwatidde ekisuumu n'okutuusa kati twafuna court order wansi magistrate court eragira nti babaddize property yaabwe n'okutuusa kati bakyaganye babajjako computer babajjako ebiwandiiko byonna n'okutuusa olwaleero ebitannabaddizibwa. Naye kati nga batufunye ekiragiro ekya high court wano katusuubire nti luno bagenda kugonda batuwe passports ezo zijje wano kuba ndoza kyekigenda okutulwisaamu akatonotono ekyokufuna passports ezo okuzijja mu state nera nga tubagamba nti bagondere ebiragiro bya kooti. Bajeemera ekiragiro kya kooti ekyewansi esooka yabalagira nti batuwe passports ezo n'ID ne bagaana. Babalagira abalwadde baffe babeexamininge batuwe medical reports naye medical superintendent waabwe mukulu Alex Kakoraki yatuwaddeko emu ya makoka Samuel. Kakati nga bwe tufunyeyo ekiragiro ekisingawo ekya high court ekigamba nti passports ezo zijje wano katusuubire bagenda kigondera mu bwangu ddala. Ndowooza bwe bukwakulizo bubiri bwokka abantu baffe bafulume. saako ffe kakunoonya ssente ezo tugenda zinoonya mu bwangu tulabe nti zijja then nga bwe tubatolinga ne state etuwe passports tulabe nti abantu baffe bavaayo. Basically byebyo ebisigadde tukyabatolinga nabo katusuubire nti banaakomplyinga ne order za kkooti.
bwetyo kkooti bwetambudde gwe omugoberezi waffe wa CTA News tukwebaza okuba nga ate otambudde naffe era tukwebaza okwerekereza byonna n'obeera ng'otugoberera okwereza data n'obudde. Tukwebaza byansusa ate na subscribinga banaye subscription ezo ziwere. Tubeebaza okubeera nga ate mutugoberera ebyensuso bwebityo n'okutwagala. Miliyoni 7.2 zezo nga Lodi Meya bwategeeza bwalambudde zezeetaagisa kw'otadde n'ebiwandiiko byabo abakwatibwa okubeera nga bikomezebwa oba bireetebwa mu kkooti nga omulamuzi bw'alagidde. Kati bwe bityo bwe bigenze, abantu baweereddwa okweyimirirwa era abantu baabwe bagenze n'akamwenyumwenyu nga bamanyi nti akadde konna ate baddamu okubiyunitinga. Tubeebaza tubaagaliza akadde akalungi